My name is Ronald Soufflet, resident of Houma, Louisiana. I'm a retired school teacher and administrator. My testimony is on corruption in federal criminal court, and it exemplifies over-incarceration and over-criminalization. My son, Christopher Soufflet, is a federal inmate 28 months into a 70-month sentence. Testimony I present is relative to the processing of Chris's criminal case in the Northern District of Georgia. Chris operated an internet pharmacy business from the years 2000 through 2003 and was indicted in 2006 for violations of the Controlled Substances Act. From the time he opened his business to the time he closed, he utilized the services of prominent attorneys and firms, including the services of 3 former federal prosecutors. Between indictment and trial, approximately 18 months, Chris's defense focused on his advice of counsel defense because no attorney or firm ever advised him that his business may be unlawful. None severed their association with his business, and they had created the legal framework for the operations of the business. Federal prosecutors obtained defensive evidence in order to prepare their case against his advice of counsel defense. But 10 days prior to trial, prosecutors filed a motion to exclude the use of advice of counsel defense. Then they issued a 3-day plea deadline. On the deadline date, the defense filed a counter motion. Chris reluctantly agreed to the plea, and he was rushed into court the next morning to formally enter into it. 2 opposing motions relative to the use of advice of counsel defense were awaiting a judicial determination when Chris took his plea. At issue was the nature of the crimes, either general intent as maintained by the prosecutors or specific intent as maintained by the defense. Prosecutors not only allowed Chris to make his crucial plea entry decision, lacking true knowledge of the nature of the crimes, their plea deadline forced him to do it. In order for a plea to be valid, it must be knowing and voluntary. The Supreme Court has held that knowing includes knowledge of the nature of the crime, including the intent element. 3 days after plea entry, the judge ruled that the alleged crimes were specific intent, not general intent, as declared by the prosecutors. No one notified Chris of this order in his favor. Chris's 2255 motion to vacate his sentence is based on the knowing and voluntary constitutional requirement for plea entry and is currently before the court. These issues are but a few of the many transgressions inherent in my son's case. Particularly disturbing is the fact that supervisory personnel in the Department of Justice have been unreachable. I welcome the opportunity to present documented evidence of these transgressions and many others to any committee hearings on such matters. I pray that this documentary will bring about awareness of the injustices being thrust upon American citizens. We want our country back.